is, that his microphone is on, correct? Mr. Bly has contacted the clerk's office and basically said he's objecting to the name change under the current rules that we're operating under by our appellate court's instructions. Anyone who is in custody that has a pending case must be given an opportunity to be heard on this issue. So we're going to have to necessarily reset your case and set up a Zoom link, either let him testify from the jail or have it heard in person, but the case will not be able to go forward today. You have to serve him with a copy of this petition.
I did.
Okay, and that may be why he's saying today, my understanding was he's saying he did not. Oh, he's saying he didn't get transported. So we're going to have to reset it. Do you have a date to reset it that you can transport him down here? April the 8th?
It would have to be after that. I do have things on the 8th. That would work.
Right, reset for April the 10th and make sure that there's a notice to the jail that he needs to be transported down for who is the judge? Wallace? Turnbow? Judge Turnbow will hear it on that day.
Okay, thank you.
All right, thank you. Sorry we couldn't go forward. Good morning. If you'll raise your right hand, let's place you under oath.
I do.
You are Amanda Ray Cunningham, is that correct?
Yes, sir.
Ms. Cunningham, you filed a petition asking to change your name, your last name anyway, and I am required by law to ask you some questions. Are you asking to change your name to avoid your just debts or creditors?
No.
Are you asking to change your name to avoid criminal prosecution?
No.
You're basically wanting to restore your maiden name, is that correct?
That's correct.
Right. Then I find there is a good cause for the issuance of the name change. You have an order?
I do.
Okay. I'm going to ask you to sign off on this order. I'm drawing a line here and I'm putting an X there. If you'll put your signature in, and that extra page is just another copy of the order, blank order, but you can keep that one. I want you to sign that and sign your new name. So the reason for I'm doing that is to make sure there's no question that you were here today and requested the name change. So.
Thank you.
All right, I've signed your order granting your name change. You can get a copy of it a little later in the morning from the clerk's office, okay?
Thank you.
Thank you. Good morning. If you'll raise your right hand, please.
I do.
You have filed a name request to change the last name of your minor child, is that correct?
Yes, sir.
And have you served a copy on the father of this child?
He is not involved. So when I went to file, they didn't mention nothing about it. So I just,
Do you know where the father is?
in Missouri is all I know.
You do not?
Just in Missouri is all I know.
Well, I understand. It's just that when you may be the custodian of the minor child, is there any court order down that governs, him having any visitation or anything else?
Just child support. That is it.
The child support agency has that, though?
Yes.
I think it's going to be required that you give him notice of your intent to change this child's last name.
Okay.
Because under the law, the rights of a parent to their child don't go away automatically just because they're not involved with the child. You would have to terminate his parental rights. Okay. So you may very well have the right to have your son's or your child's name changed, but I'm of the opinion that he's entitled to at least be given notice. Okay. And then he may come in and say, I don't oppose, or he may not do anything, and you can proceed by default. But I think you're going to have to serve him with a copy of your request before we can go any further, okay?
Just so, do I need to send that by mail or?
You need to, I can't give you legal advice.
Oh,
The
okay.
clerk's office may be able to tell you, but you're going to have to serve him with a copy of it so that he's aware of your request, okay?
Okay, perfect. Thank you so much.
All right. Ms. Hopwood, you are, is it Lenny?
It's Lena.
Lena? Ms. Lena Hopwood, you are here today to ask that your name be changed. As you heard me say, I'm required to ask you a couple of questions. Are you asking to change your name to avoid your just debts or creditors?
No,
Are you asking to change your name to avoid criminal prosecution?
no,
It's my understanding that you just want to get your driver's license to match up with all your other paperwork, correct?
yes,
All right. Then I will grant your request for a name change, or you have an order. I'm going to do the same for you. I always require that the person seeking to have their name changed sign off on it so that in the future, there's no question that you were the one who requested this to be done. All right. I will change your name to Lanny Alice Hopwood. And I've signed your order. As you heard me say, you can get a copy of it from the clerk's office in a few minutes when they transport it over there, okay? Both of you raise your right hand. Let's place you under oath. All right, this is a petition that's been jointly filed by you to change your name, change your minor child's name, is that correct?
yes,
And you want to change your child's name to Damian Nathaniel, how's it? I can't
Ludlam.
read it.
Ludlam Carpenter.
Luckham
Yeah.
Carpenter? Okay. And his full name presently is Damian Nathaniel Lee Kress. And you're asking to change it to Damian Nathaniel Luckham Carpenter.
Yes,
Okay. And you are the biological mother of Miss Ludlam,
yes,
and you are the biological father, Mr. Kress.
Yes.
And both of you are in agreement that this is in your child's best interest? You're not attempting to change his name to avoid any sort of civil prosecution, any debts or creditors that you may own or that may have some relation to your minor child? You're not asking to change your name to avoid any sort of, his name to avoid any sort of criminal prosecution? And why are you wanting to change his name, just out of curiosity?
He's actually not in his life anymore. He has another man that is his father, and in the future, we're gonna do an adoption.
But Mr. Kress is the biological father, and you're in agreement to change the name. All right? I will change the name. It doesn't change any other parental rights that Mr. Kress as the father may have. But I'll change the name at your both requests. Okay?
Thank
You have an order prepared?
Yes.
All right, we're going to give you this back and have you both sign off on those two lines I've drawn, and both of you as the parties will need to sign off on them, okay? On agreement of both parties, I'll sign the order and grant your request for a name change. Thank you. You can get a copy a little later in the morning from the clerk, okay? Thank you.
This is a petition to register. There was a custody matter that was filed in Yolo County, California, back in 2023. Pursuant to that custody agreement, the mother was granted permission to relocate with the children, ages 13 and 10, back to the state of Tennessee. She has been here, and we filed back in October of last year a petition to register the foreign decree. We attempted to serve the father, and we made concerted efforts to serve him, and he refused to cooperate with the service. I personally, as an officer of the court, spoke to him. He contacted my office after about 4 times of me sending a private process server to serve him, acknowledged that he knew that a process server was going to try to serve him and that he wasn't going to accept it. So at that point in time, I came before the court and asked permission to serve him by publication. And we have served him by publication. We served him as filed with the court. I discovered a newspaper of general circulation in the county where he lived, and that is the Daily Democrat in Woodlawn, California. We filed that, and the dates of publication were February 6th, 13th, 20th, and 27th. No responsive pleading has been filed, so I filed just a motion to set, Your Honor. It's just to register the decree. We're not asking to modify the decree. We're not asking to modify the decree.
Well, I was looking for what I was going to be setting for a final hearing. but-
Yeah, it's just, I've done an order. It's just adopting, it's just allowing it to be registered so that I can then send that to California to get a certified copy. I filed a copy with the clerk, but I need to get a certified copy. And it's just a scenario with, we've got a 13 and a 10-year-old that we just need to make sure that this court has jurisdiction over them now, because they do live, if you need testimony, they have lived here. And so that's the reason we're registering it.
Do you need to put on any proof? It's basically, under the statute, you just have to file your judgment and serve him with a copy, and if there's no opposition, then it.
Right, and
Yeah,
there's
right.
not, but again, we've set forth a specific pleading that's sworn to, so I don't think the necessity is for any additional testimony is
All right.
required.
Thank
Thank you,
you.
Your Honor.
I've signed your order. Diversitas Holdings LLC versus Thomas Shane Sullivan, also known as Thomas Shane Sullivan.
I'm here for the Diversitas, Your Honor.
All right.
This is kind of similar to the last one, where it's just a enrollment of a foreign judgment. The defendant made a sort of bare bones assertion, so we had to file a motion for summary judgment on that, and there's been no response to that. So we're just seeking entry of a summary.
You, Thomas Sullivan?
Yes, sir.
Mr. Sullivan, let me explain to you the status that we're in right now. A judgment was entered against you in a court in California, and I believe the amount of that judgment was some $88,892.14. That was rendered back in September of 2025. Then the credit holder, or the judgment holder, Diversitas Holdings, has brought this to the state of Tennessee, and they filed it under a statute which allows them to domesticate a foreign judgment. That's the process that we're talking about. And what that statute provides is that they can file a copy of the judgment here, serve a copy of it on you, and then unless there's some basis for not allowing it to be domesticated, it would be automatically domesticated. In this case, you filed a pro se or a handwritten objection to it that I don't know if Mr. Townsend, were you aware that he had filed that, I assume?
We were, Your Honor. That's why we filed the motion for summary judgment.
And because of the fact that you filed an answer in November, basically saying that it was taken care of by the finance company and you were told it was over, that I'm treating as an objection to the domestication of the judgment. So what Mr. Townsend has done on behalf of the plaintiff in this case is file what's called a motion for summary judgment. And that motion for summary judgment is under a specific rule of procedure. And that rule of procedure requires them to file an affidavit setting forth all of the facts, as well as a statement of undisputed facts. And a motion for summary judgment is to be granted by this court if there is no dispute about the material facts in the case. The process required you within a certain period of time after you were served with this motion for summary judgment to file a response, including a statement where you objected to the statement of facts that the plaintiff has supplied. You would have to object to those or agree with those, and then you would have to submit facts of your own. It's a bit of a complicated scenario.
Yeah.
But because you have not done any of those things, then the plaintiff in this case is under the rules of procedure entitled to their judgment to domesticate that foreign judgment under the motion for summary judgment. Does that make sense to you?
No, would you
It may
allow
not,
me?
but have you consulted an attorney at all about this?
That's what I was just gonna ask. I don't understand it because this is almost 10 years ago. I mean, I was in a 3-year lawsuit and Tim Potter was my attorney, and Maximum Finance was the lien holder or the financing company, and they told me that everything was good. They cleared it. I ain't heard a word over this in years, and now,
Well, let me do this. Mr. Townsend, I realize that this is a little bit unusual, but we're required to try to err on the side of caution to try to help pro se litigants. I'm going to reset your motion for summary judgment to allow Mr. Sullivan to consult his prior attorney because
Thank
he's under the impression that this matter had been resolved by an agreement. You may also contact Mr. Townsend and have them explain it to you, but if you want to contact Mr. Potter, who is your prior lawyer, we're going to give you that opportunity, but it won't be reset for a real long time. So I'm going to reset it for that April 10th day.
Your Honor, I only have a small objection to that, and we'll obviously allow, abide by that. The only objection was that Mr. Sullivan told me the same thing back in November in October when he was served, and then has spent several months doing nothing on this except for a small handwritten response, and has never come back to us explaining his reasons for that. And so that's our only objection, Your Honor.
I understand. And obviously, a layperson does not understand the procedures as well as someone who's trained in the law. And that's the reason I'm erring on the side of caution to give him an opportunity to at least talk with his prior attorney. Mr. Potter is a good lawyer. He's available here in town, so it shouldn't be a long delay. Are you available, Mr. Townsend, on April the 10th? Is that your date?
Let me see, Your Honor. I need to look at our travel schedule. Your Honor, I may have to be in Blount County on the 10th.
What about the 8th? What's your next chancery?
I could do April 8th, or are you talking about May 8th?
Let's do this, April 22nd. April the 8th is just next week, I think, so.
Right.
April 22nd?
Let me double check. I think that will. No, sorry, Your Honor. I have a motion for summary judgment that day in Morgan County. So
What about the 24th? April 24th. I'm happy to get these days because
that should work, Your Honor.
I'm sorry, is that day okay?
That day will work, Your Honor.
All right, April 24th. going to give you that much time to you need to go immediately to see Mr. Potter and explain to him, make sure you've got copies of what all is going on and let him
I hope
take
he
a look
does.
at
Like I
it.
said, it's been almost, ain't there a statute of limitation on stuff?
I can't give you legal advice. That's why I'm giving you an opportunity to talk to Mr.
I
Potter.
was just wondering why they would wait this many years to,
Well, that, practically speaking, that should have been raised in the California court that was.
well, I was in Tennessee, like I said.
All right. In any event, let Mr. Potter know you need to speak to him, and then we'll reset you on the 24th for Judge Turnbow to decide the case. All right, thank you.
Will that be the same time, Your Honor? Do you want us to send those to hearings?
Thank you. 9
I'm
o'clock.
sorry. 9 o'clock. Okay. Thank you, Your Honor.
You're welcome. All right, and then the only other thing we've got is the Hinton versus Hinton, which is Ms. Roberts' case as well. And that's a Humphreys County case that I agreed to bring over to try to conclude today. All right, since Ms. Roberts is working on the resolution of this Dixon County case, before we begin the Humphreys County case, we'll take a recess. Please let me know as soon as. Yes.
May take a while, may take a while to do the UDA on their part. You can speak with yourself.
Are you done with it?
Oh, okay. I think we've gotten a settlement in the Jordan matter. Ms. Duke was kind enough to go on and get it typed up. I just need to review it. So I don't know whether or not you wanted to give me a second to review that final decree that we can submit to Your Honor to settle the Jordan matter, or whether you want us to start the Hinton matter, and then when you take your 10:30 break, just give me a little bit longer at that point in time to review it.
I don't care. I got to hear them all anyway, so matter of.
Well, I would
what's
prefer
better
rather than the Jordans having to wait.
I would prefer to settle the Dixon County matters completely and get in the docket on the Dixon County so that we can then start the Humphreys County matters.
Yes, if that would be my preference also, if Your Honor doesn't mind.
Then we'll take a recess to let you do that.
Thank you, Your Honor.
Motion to withdraw or in the alternative continue this case. Mr. Kaiser is adamant there is missing body cam footage. So I was gonna request a continuance to investigate that. Aside from that, he just really hasn't been listening to my advice or really having much to do with anything that I have to say.
You have a motion to suppress down today, correct? And your motion to withdraw is based on the fact that there's supposedly some missing body cam footage?
Yes, that's correct.
What evidence do you have to believe that there is actually any missing evidence?
I've talked to Mr. Woodall. I personally don't have any reasonable belief there would be, but I followed it just out of abundance of caution.
Can I say something?
Yes, sir.
Mr. Ted Cox got it, and I've notified him ever since I've been in. He's talking about his office is getting renovated. He don't have time to find it. Because he was my attorney. I had, in my discovery, it was one fiber out, whatever you plug into those to look at your discovery. He had one. She has four. And the one she had Mr. Cox didn't have, because I think it was extra to it. It was a lot more to it than what's been asked. So I asked her to get what she has sent off to the lab, to the TBI to make sure, because I know it's been tampered with. Because that ain't what I'm seeing. I know what he showed. But since he stepped down, now his office is in renovation. He didn't send it, and the things that I read is like he shouldn't even done nothing with it until 2 years or a few years after my case is closed. So why is now all of a sudden it's gone? And he keeps sending different stuff. My discovery pack was filed with Runyon. But since
So how many
then,
different lawyers have you had?
Runyon, he stepped down because he's a friend of the sheriff's, which had nothing to do with this case, but the courts allowed him to do that. She's a relative to the police that's on my case. So really, I can't be truthful to her.
On this case, Jay Muller, Stewart County Sheriff's Office?
No, on the ones that's also set for
We're
today.
not worried about
What's
that
the
one.
ones that's set for today?
The one that's set for today is the motion that the case that's set for Thursday, is it Thursday?
Yes, Your Honor, it's Thursday.
Set for Thursday for trial, and those charges are possession of a firearm by a felon, revoked license, first offense, the unlawful drug paraphernalia, and seatbelt violation. That's the only case that is set for Thursday.
But I was told I had cases set today, and it's not the one she filed. It was for a four-wheeler and a Class E felony, a class for evading arrest. That was also set for today.
That's set for status apparently, but it's not
Right.
set for trial.
Yes, I can't be truthful to her when it's just a conflict. I mean, I've asked her to file those motions. Every time I ask her to file something, she says she's got to ask the DA or go to the DA. The DA is not working with me. I'm working with her. So even her uncle told my wife that the DA is going to prosecute me. So how does her uncle know? Let's just get it talked about around the kitchen table. I cannot trust that. So I've spoken to 2 attorneys that I was going to hire, but I'm in jail, so I can't hire. But like again, she's handled a lot of stuff of mine. But when I ask her to file something, it's always, but the DA said this, the DA done that. But what about the evidence that we supposed to be collecting? She hadn't investigated where I was pulled over at, the why I was pulled over, the body. It's a lot to it. It's a lot to it. And I can't even address nothing with her because it's not confidential. It goes from her mouth to her uncle's mouth or to the DA's mouth, and I can't do that. That's why I don't talk to her. She told me the first time I talked to her, I know her dad. So I said, how? She won't tell me.
I have not disclosed any information regarding this case to anyone, so.
Well, I was made aware of the obligation or the argument that you had to make about her situation. I'm not so sure that my first inclination was that I was not going to grant her motion to withdraw and I wasn't going to continue your case because it's been pending since 2021.
Yes, sir.
And she is the 3rd or 4th lawyer that you've had appointed, and we keep appointed lawyers, and then there's some issue. Be quiet when I'm talking.
Yes, sir.
That there are several times that that's has to happen. My concern now, generally, despite what we have discussed in the chambers, is that Ms. York is being placed in a situation where she's likely to not have a good way out of it. If she continues in the case because I don't grant her motion to withdraw, then it seems to me that that will create an issue for post-conviction relief that otherwise would not be present if she is allowed to withdraw, and that resolves the issue about supposedly the lack of discovery, although I'm of the opinion that this is a pretty straightforward case. I mean, it's a case of driving on a revoked license and in possession of a handgun. So I don't know how the evidence could be that, but the state is objecting to a continuance and a motion to withdraw.
That's correct, Your Honor. State's, it's the state's opinion. This is Mr. Kaiser's another attempt, Mr. Kaiser, just to delay this case. Been going down the road. State's been ready since Mr. Runnion's had this case. The state's been ready since Mr. Cox had this case. The state's ready for trial Thursday. Understand your ruling.
Clemens, what conflict does your office have with this individual?
I don't recall the exact conflict. I think it might have been that there was PCR filed against our office. Mr. Kaiser?
That's been 25 years ago.
Your Honor, I'm happy to be stand-in if you needed appointed counsel, and I could probably go forward with trial on Thursday as well if I can get the discovery today.
And you're Mr. White?
Yes, Your Honor.
Well, I'm going to allow Ms. York to withdraw on her motion based on the fact that she has divulged that there is some relation between her, someone in her family distantly has some relation to another case that this defendant has. And I'm of the opinion that it's puts her in a position where the appearance of impropriety could attach. So we're going to protect Ms. York from having that issue raised by allowing her to withdraw, and I'll appoint Mr. Kendall White. Now, Mr. White, you can talk with General
I'll be glad to talk.
Will about it and see if you can be ready for trial before I leave today. I just need to know if we're going through with the trial on Thursday. So,
Yes, Your Honor.
all right. Thank you, Ms. York.
Thank you, Your Honor.
Judge, I have speaking of trial settings, I have an easy one. Dewey Robinson is on your docket. If we could set him for trial, I don't think the state and I will be able to make it. Any kind of,
Who was it? I'm sorry.
sorry, Your Honor.
Who was that?
Dewey Robinson, Your Honor.
Clerk is throwing files out. Louis Preston Robinson on page 7 of the docket. Do we need to set a trial date?
Yes, Your Honor. We need a trial date.
We can set it behind Paul Davidson, like in August,
And that date is
the 8/11. We do that.
August the 11th.
August the 11th, Your Honor.
Right.
I'm available. That works for us.
There's one priority before.
It's not an urgent.
Now, with what my rule is under this scheduling order that we put down, that once it's set for trial, then he'll go to trial or he'll plead to the sentence, plead and go to sentence.
Yes, Your Honor.
All right, thank you.
Your Honor, I also have Miss Amber Hayes on the docket.
All right.
Your Honor, Miss Hayes, we're in an interesting situation here. It's taking me a little bit of work, but she has over 2,400 days of credit on this sentence. It's a 8-year at 85%, 8-year 30%. You've served 85% of her sentence at this point, Your Honor. I know we are here on a pending violation. However, with that many credits, it'd be remiss of me to just say plead guilty and other than terminate because she's hit over 85% of her 8-year sentence, Your Honor.
Have you talked to the state about whether they would agree to that?
I talked to the state, and I don't know that they're in a position to do that because of Mrs. Hayes' record with this court, particularly.
That's correct.
You know, Your Honor.
Carlos not coming back to court, and then I believe she has new charges.
All right, so you don't have an agreement. So the question is whether or not you want a hearing or you want to just, if you don't want a hearing, you can plead guilty and go to a sentencing hearing, or you can have a hearing on whether she's violated her community corrections. That's up to you. But as far as me predicting what I'm going to do, I'm not, I don't give advisory opinions.
Your Honor, let me have a minute to come forward with my client, and then we'll come back.
All right, then,
Yeah.
I think we can take up the state versus Peter
Yes, Your Honor.
Bargality tried. All right, there are several motions. The first motion is your motion to dismiss counts 1 through 8 based on the statute of limitation.
That's correct. That's the defense motion, and in looking at the tolling statute and case law, the state
is conceiving the misdemeanors, Your Honor. They are time barred.
Misdemeanors must be, prosecution must be commenced within 1 year from the date of the.
There's no proof that he was actively avoiding.
So counts 1 through 8 are dismissed by agreement based on being barred by the statute of limitations. All right? And you have also motions.
Well, that would be misdemeanor, not count 1, Your Honor, because that's the email. Just the misdemeanor count. So that would be count 2.
So the counts 2 through 8 are what you're dismissing.
For Peter, it'll be count 3, 5, and 8. Because the co-defendants are charged together. Mr. Sogsod will get rid of it.
All right, so counts 3,
5,
5, and 8.
let me make sure that
I'm looking at the indictment, and those do appear to be the ones.
Okay.
And then you also have count 1 and count 10. And those are the 2 that Mr. Clemens is planning to argue about. Mr. Clemens, I will hear your argument. I think your motion is to dismiss count 10, which I think count 1 and count 10 both are covered by your first motion to dismiss count 1 through 8. And then count 10, you've also got a motion to dismiss for failure to state an offense.
Your Honor, of course, the 2 motions, count 10 is within the statute of limitations of being a higher class of felony. So it's not an argument as to statute of limitations. It's only
Failure to state an offense.
If I may, I'll launch into my arguments as to count 1 in the statute of limitations.
All right.
Your Honor, in this case, there's a superseding indictment which came out on July the 7th of 2025. And it alleges in count 1, a Class E felony, criminally negligent homicide that supposedly occurred on July the 1st, 2023. Therefore, on its face, this indictment is beyond the statute of limitations. It's been 2 years. It's about 6 days late. The law would allow a superseding indictment to indict the offense after the statute of limitations if the offense had previously been indicted by a prior indictment. This would then only replace that. And so I looked in the file to see whether, in fact, a prior indictment within the statute of limitations had been issued, and found, to my surprise, the answer appears on the record, at least, to be no. Prior indictment was from the May term of the grand jury in 2025, and it has, amongst its charges, there is, under count 2, an indictment for criminal negligent homicide, which matches the language in the superseding indictment. However, when I go to the back of the indictment, I see that there is a list of counts, and next to each is written either true bill or no true bill. And count 2, which would have indicted my client criminally negligent homicide, is not listed on that indictment. This should be apparent from the file. And so for that reason, with nothing to show that my client was ever indicted for criminally negligent homicide under count 2, we cannot show from the record that there was any indictment for this offense prior to the superseding indictment, which, as we've noted already, was 6 days late. Now, on that basis, I would ask that the case be dismissed. Now, I will grant that in my informal discussions with the district attorney's office, they say that this was an oversight, a clerical error. Perhaps it was, but if it was an error, I don't know that it was made by a clerk. And even if it was, I think the error is a significant one. Something as significant as forgetting to write that a person was indicted for homicide is significant. It cannot be cured by the later indictment because it is beyond the statute of limitations. I do not know, even if this was some sort of error, whether Your Honor could or should allow the state to correct that error at this time. If they made a motion to correct a clerical error, I do not know exactly what proof could be presented to Your Honor as far as what testimony may or may not have been heard by the grand jury as to whether this indictment could have or should have been issued. But as the file stands right now, my client was never, according to this file and according to these indictments that I did provide with, indicted for this criminally negligent homicide until after the expiration of the statute of limitations. On that basis, I would ask Your Honor to dismiss.
All right. General, you want to respond to that, and then we'll move to his next motion.
Your Honor, I did file a response, I believe. I hope that Your Honor's had a moment to read that. It is a clerical error, Your Honor. I can be sworn in and testify if I need to. And I have Ms. Glenn here. She prepares my indictments and I approve them. General Kraus approves them. But if you look on the back of the first indictment for May, the issue is there are 2 count ones. The first one, count 1, 3, 5, 7, 8 are for Socksog. And the next was supposed to be 2, 4, 6, and 9 for Peter. The only issue is there are 2 count ones. When under Peter's charges, it should have said count 2 instead of count 1. So when we realized we were going to supersede that to do the Miss McDonald as a victim in July, all we did was shift the count 2 that was indicted up count 1. We did not represent this charge. Count 2 was a true bill in May. Count 1 for Sogsog was the no true bill. It is simply a mistake on the back of the indictment. Instead of filing a motion to correct, we just shifted the count up in July. So Mr. Fagelgrad was indicted on count 2/count 1 in May, well within the term of statute of limitations. It's a simple clerical error, Your Honor.
You wish to be heard anymore?
Yes, Your Honor. Your Honor, the Assistant District Attorney has generously offered to be sworn in and to testify for the purpose of being able to say, well, the grand jury actually did vote to indict him for this particular charge. The problem with that I see, it would be that the district attorney is not allowed to be present at the grand jury when they are doing these things by my reading of the law. And it would seem that if we wanted to prove such a thing, we would need to call a witness that was actually there. For example, we could call some of the grand jurors, perhaps ask them, hey, did you guys vote to indict this man for criminally negligent homicide? And if we had perhaps the foreman of the jury say, well, yes, we did. And then I would ask him, well, why doesn't it say so on the paperwork here? And if he said, well, I forgot to write it down. I forgot to write down count 2. I didn't notice that. We would still then have to decide whether this is the sort of error that can simply be overlooked. But without such proof, I don't think we're in a position to do that. And based on the record, I ask that Your Honor consider dismissing this case.
Well, this court finds somewhat differently in that when the review of the May 2025 indictment, the original one, not the superseding one, the back of the indictment has certain hand notations made. And clearly, the count 1 as to this defendant shows criminally negligent homicide as a true bill. The count 1 also is shown as to Benjamin Sogsog as not a true bill. The error was not in the handwritten portion of that by the grand jury, but rather in the counting of the indictment counts, because there are 2 count 1s, when obviously one applies to Mr. Sogsog, the other to Mr. Whatever, the defendant in this case. It is clear to this court that there is a topographical error made by the district attorney's office in noting the number of the counts themselves. The actual face of the indictment or presentment does show that count 1 applied only to Mr. Sogsog, and that count 2 was to the defendant in this case, and that was a criminally negligent homicide count. So therefore, the court finds that this was an error, a Scrivener's error, or an error in the preparation of the indictment as to the number of counts, but not the offense for which the defendant was indicted, and that has been corrected by the superseding indictment. The purpose of the indictment presentment in any event is to notify the defendant of the crime that he is charged with. And the court is of the opinion that he was given plenty of notice and that this is not a matter where the grand jury failed to indict him. In fact, it says just the opposite. They indicted him on criminal negligent homicide. It's just the number of the counts that was the error. And that was on the part of the district attorney and not the grand jury. And for that reason, this court is of the opinion that the motion to dismiss based upon that reason would be dismissed, would be denied. We have another motion as to count 10, failure to state a cause of action, if I understand correctly.
Yes, Your Honor. Count 10 of the indictment charges the defendant with reckless aggravated assault. It states that he did unlawfully engage in reckless criminal conduct with a watercraft that resulted in the serious bodily injury of another person. To wit, and here's the portion where they would describe his reckless operation of the watercraft, says the defendant was the adult passenger of a personal watercraft that was being operated by a child under 12 years of age who was operating recklessly and thereby collided with another personal watercraft, causing serious bodily injury to Caleb McDonald. On the face of the indictment, then, you can see that no reckless conduct is alleged against the defendant. It is said only that he was a passenger of a watercraft that was being operated recklessly by somebody else. Reckless conduct by somebody else cannot be attributed to the defendant unless the defendant does something reckless himself. It is only alleged that he was a passenger, and Tennessee law does not permit a passenger to be charged with reckless assault based on the operator of a vehicle's reckless conduct as alleged. And when the facts, as in the indictment here, affirmatively negate an essential element of the offense charge, that is, there is no reckless conduct alleged to have occurred by the defendant, it is subject to pretrial dismissal. We ask that Your Honor consider doing so.
Your Honor, the state also filed a response to this motion. The key words to pay attention to in count 10 are that the personal watercraft is being operated by a child under 12 years of age. Under the voting statutes, Your Honor, 69.9101 and 69.9505, that would put the adult passenger as criminally responsible for that minor child operator of watercraft. State argues that this is more of a factual issue, as the facts would show that the defendant was unable to take control of the vessel, which that's what the law requires when an adult is on the back of a PWC. And the facts would show that he was unable to do that, and that was the reckless conduct, Your Honor. So we charged it under criminal responsibility theory.
All right. Clement, do you have anything further?
Yes, Your Honor. Part of what's going on here is that for someone to be criminally responsible for the conduct of another, would have to have some sort of mens rea, something going on in their mind and something going on in their actions that links their criminal conduct and is the same as the reckless conduct. Even if we were to grant that he was in some way negligent, then it still would not rise to the level necessary to be able to indict him for a reckless crime, as the state has attempted to do here. For that reason, I ask that Your Honor consider dismissed.
The indictment in count 10 alleges that the defendant was an adult passenger on a personal watercraft being operated by a child under 10 years of age. Tennessee Code Annotated 69.9505 states the following: it is unlawful for any person under 12 years of age to operate a personal watercraft upon the waters of the state of Tennessee unless such person is under the direct supervision of an adult. Direct supervision means being in such a proximity with an operator as to be able to take immediate control of the vessel. In reviewing the Tennessee Wildlife Resource Agency's investigation, Their findings are that the defendant was not in a position where he could take control of the vehicle, and therefore he was in violation of that particular provision of the law. The count that we were talking about alleges that he engaged in reckless criminal conduct by being a passenger and allowing the child of under 12 to operate the motor vehicle that, or the watercraft rather, that collided with another. And I think that in the reading of the statute that the child was prohibited from driving unless this individual was able to control it, and reading the facts as set forth in that investigation, this court is of the opinion that it does become a factual issue for the jury to determine whether or not he did it, whether his violation of that statute considered to be or would be considered to be such reckless criminal conduct as to render him liable for. I think that is a factual nice. And the defense is free to renew its motion to dismiss following the trial of this case, so that my opinion is that the indictment is sufficient to put the defendant on notice of the charge and the basis for the charge, and it's a matter of factual basis whether the jury would find that there is a proof beyond a reasonable doubt that he is engaged in reckless criminal conduct. And I'm allowing the defense to renew this motion following the trial of this case to determine whether or not there is a basis for a dismissal. That is my ruling. Your last one is a motion for bond. Are you ready on that?
Yes, Your Honor.
And you have both a motion to set bond and a motion for individualized bond determination, which is basically an application of the bonding rules. Pretty much what I do in every case anyway. So
Yes, Your Honor.
any reason for a different hearing in that?
No, Your Honor. I would proceed as a normal bond hearing.
And I'm ready to hear it.
Your Honor, I would like to first offer as an exhibit the report of the Tennessee Wildlife Resources Agency, which I previously provided.
You've given me a copy of it, and I have it here, so I'm going to provide that to the clerk.
And I would like to merely draw the court's attention to the facts as presented in there and the conclusions of law enforcement at the end, which conclude that as far as any recommended charges, that they recommend that perhaps Mr. Fagot-Jagrad might be charged as an accessory to the misdemeanor violations of allowing that and more. No such things as homicides or assaults is recommended by that report, nor I would say is strongly supported by the facts. The facts as set forth in the report are straightforward. Mr. Fagot-Jagrad was one of two passengers riding along behind the operator of the personal watercraft, who was following along behind somebody else's personal watercraft. The one in front turned in front of the one being operated behind it, and the one behind it continued on straight, and they collided. If this were a civil trial, we would be throwing around terms like contributory negligence. We might look into whether the operator of the other watercraft had any responsibility for these actions. Of course, my client would be a potential plaintiff in such a suit, even being injured in the incident as well. But for our purposes, it's much more limited. He is being charged with criminally negligent homicide and reckless assault based on the theory of criminal responsibility for somebody else's reckless conduct. He is also co-defendant along with the child's father, who we would say is the one more responsible for making sure that the child is old enough to operate a watercraft and is wise enough to operate it in a non-reckless manner. I would also like to present as an exhibit, if I may, this is, can I pass this up, please, Your Honor? I've taken the liberty of getting a diversion eligibility certificate, and I would like to pass that forward for the purpose of demonstrating that my client has no prior significant criminal record and is facing, at this point, a Class E felony, and I believe a Class D felony at most, for which he would be eligible for a post-trial diversion even if we were to go to trial and lose. There is no intentional bad conduct alleged against my client. It is not clear from the report that he even knew the age of the person who was operating the watercraft. And I would think that may become significant as to what level of proof he had to show that he can say that he did anything wrong. His bond is, I think, $50,000 right now. And Your Honor has already, with the agreement of the state, seen fit to dismiss most of the 10 charges against or rather the 5 charges against the others were related to the other person. In consideration of all this, Your Honor, we ask that the bond be lowered and that he be allowed to make a more reasonable bond. We would suggest at most $10,000 for this case and allow him to be out of jail on a reasonable bond while awaiting this trial, which will take a few months to get put together.
All right. Anything other than arguments you wish, and these 2 exhibits that you wish to offer?
No, Your Honor.
State, have any proof you wish to offer or argument you wish to make?
No, we defer to the court on here issue of bond. Mr. Bagelcraft does not have a criminal history. It did take a while to locate him within the country. That's the issue. We just want to make sure that if he's given a bond and he's let out, that there is some sort of way to make sure that he's going to be available for trial. We had to have our investigators on efforts located and we extradited your owner. So that's
May I ask a question? Is your client here under a valid visa?
Your Honor, I'm glad you asked that, and I meant to bring that up. My client is, yes, he is. He is from Micronesia, which I didn't know much about until I got this case, have to be honest.
Nothing about it.
It's a U.S. territory by similar to, but not exactly like Puerto Rico. He is a U.S. citizen. He's not an
So it doesn't require, excuse me for interrupting, I apologize. It doesn't require him to have a passport to go to his home to come back to the United States, to the mainland United States.
I think my understanding is it does require a passport, but it's not like he's from a different country. We've got some sort of treaty along with him, which essentially treats him as a citizen. He's free to live and work in this country right now, which he's been doing. And I would certainly accept any reasonable orders to say not go back to Micronesia, which he has no plans to do so at this time. And I would emphasize that it would be very foolish of him, and he would have every incentive not to screw any of these things up because of the nature of the charges against him are what they are, because of his opportunity to, even in the worst case scenario, be even eligible for diversion. It would not have any particular consequence for him as far as immigration, if we could tell, because as I said, he's not really an immigrant in any sense. And so for all those reasons, Your Honor, I would ask that a reasonable bond be set.
This is a tragic case, and I've made the counsel for both parties aware of the fact that the person who was killed or deceased as a result of this, Mr. Roy Heron, was someone that I had had met a couple of times. He was not a friend in any stretch of the imagination, but I had met him on a couple of different occasions when he was running for public office, among other things. But I don't think there's any basis for me to recuse myself, and I've made the lawyer aware and there's no objection. But it is a situation where it's a tragic circumstance. Mr. Heron and a young lady were on a watercraft, and as they entered into the neck of an outlet, so to speak, at the lake, Kentucky Lake, this other craft operated by a boy who was 11 years old at the time, and also had the defendant on the very back end and another child in between, came behind the Heron's watercraft, and then there was a collision that occurred, and Mr. Heron sustained what ultimately came out to be fatal injuries. So it's a tragic circumstance. As Mr. Clemens has pointed out, there are a lot of car wrecks that occur from negligence that are not criminal in nature. In this particular case, the state has alleged that there was a violation of the criminal statute, and as a result, it is a criminal case. The defendant, by proof before the court, has no prior criminal record, and as a result of the dismissal of about 5 of the charges against him, it leaves him with 2 still significant cases. against him. And for that reason, I'm of the opinion that the motion to reduce his bond is, should be considered by the court. The court is required to look at the factors set forth in 4011-118. Those include the defendant's length of residence in the community. It's not shown that he was a resident of this community. In fact, he's a resident of Micronesia who's here in the United States under based on my questions, he's here with either a proper visa or has a legitimate legal residence here in the United States, mainland United States, whatever. I don't have any evidence about his employment status, family ties or relationships. I don't have any evidence about his character or mental condition. I do have on number 5 in this factor, he has no prior criminal record. The nature of the offense, apparent probability of conviction and likely sentence. Obviously, with no prior criminal record, the defense, even if convicted, would be asking for a court to consider the judicial diversion statute as part of the sentence. The nature of the offense, again, this is an offense which clearly is somewhat creative is not the right word, but it is unusual. And there's no strong likelihood that the defendant would be convicted. I think it's going to be a question for the jury, as I pointed out earlier. So that factor would be a factor in favor of the defendant. I don't have anyone who is a member of the community vouching for him. He has no ties to the community that I can be aware of. Number 9 is any other factors indicating his likelihood to appear. I think that he's lawfully present in the United States, lawfully present here. He has no prior criminal record. This is a tragic case, but his responsibility is different in that he's not the one who actually committed the crime. He is the one who had responsibility for a child who committed the crime. And I'm thinking about that 11-year-old boy now who has to worry about living the rest of his life being responsible for the death of another individual. That's a tough situation. In any event, I'm of the opinion that the bond should be set at $15,000. The only conditions I would place would be that Mr. Faljakrad should surrender his passport to the clerk of this court if he intends to stay within, and if he's going to exit the United States, he'll have to file a motion asking for leave of court to leave the United States mainland. And he is to stay in touch with his attorney and make sure Mr. Clemens has his current mailing address and contact information at all times. That's a condition of his bond. Right. Then that concludes everything. Are we setting him for status? We haven't set him for trial, have we?
Your Honor, I would ask that we go ahead and set a trial or admit that.
Fine with me.
In 2 years, I want to get this thing moved.
Well, we didn't get your client in custody until January of this year.
Do what?
We didn't get Mr. Fables here until January of this year. So,
What started as a routine day in court quickly became a lesson in fairness, patience, and the importance of following legal procedures. The hearing began with several name change petitions, but one case immediately hit a roadblock when a mother requested a child's name change while the father was incarcerated. Even though the father was in jail, the judge made it clear that he still had a legal right to be heard. Rather than rushing a decision, the judge postponed the case and ordered that the father be given an opportunity to participate. Later, another parent appeared hoping to change her child's last name because the father had been absent for years. But once again, the judge emphasized that parental rights don't disappear automatically. He explained that even an uninvolved parent must receive proper legal notice before the court can consider such a request. The most dramatic moment came when a Tennessee man found himself facing enforcement of an $88,000 judgment from California. confused and representing himself, he insisted he believed the matter had been resolved years earlier. Rather than immediately ruling against him on a complicated legal motion, the judge paused the proceedings and gave him additional time to consult with his former attorney. The judge explained that self-represented litigants often struggle to understand complex legal procedures and deserved a fair opportunity to respond. By the end of the session, the judge's message was clear. Courts are not just about making decisions. They are about making sure every person receives a fair chance to be heard before those decisions are made.